Welcome again to the spring meeting of the American Bankruptcy Institute. I am ABI's editor-at-large, Bill Rochelle, and sitting next to me is a distinguished district judge from Milwaukee, Wisconsin, Pamela Pepper. Judge Pepper is living proof that people who wear long black robes have a great sense of humor. Just a few minutes ago, at a crowd of about 1,000 bankruptcy lawyers, she put on a spot-on imitation of Minnie Pearl. Now, if you think about it just a little bit, with the right kind of a hat, Judge Pepper can look like Minnie Pearl, but not only did she look like it, she sounded like it, she talked like it, and she had the lawyers in stitches. Judge Pepper is a rather unique biography for folks here at the ABI. She was first a clerk at the 8th Circuit. That's not so unique.
11th, yeah.
Sorry about
it's
the
okay.
wrong circuit.
That's okay.
Then she was on to be an assistant U.S. attorney for 7 years. She was then a defense counsel, of all things, representing poor indigent people who committed crimes, allegedly so. Then she went on to be a bankruptcy judge in Milwaukee from 2005 until 2014, is that right?
Into 14.
And at that point, she was elevated to the district court bench. And Judge Pepper is one of few bankruptcy judges who have ascended to Article III status. Although, if I recall, there was another judge in Milwaukee who followed the same trajectory. Is that right?
That is absolutely right. Judge Charles Clavert. It's good memory, Bill. Judge Clavert was made a bankruptcy judge in 1976. And then in 1996, he was appointed to the district court. When I became a bankruptcy judge, I got his bankruptcy seat that he had vacated. And when I became a district court judge, I now occupy the seat that he vacated when he went on senior status.
Well, I guess we ought to find out what he's going to do next so we know what you're going to do next.
I think he's going to retire and spend time with his grandchildren next, and I don't have any grandchildren just yet, so I can't do that just yet.
When you do, you will.
Yeah.
Well, let me ask you this, Judge Pepper, because you've seen the law from two very different benches. What are the similarities and the dissimilarities in being a judge in an Article I court dealing with bankruptcy lawyers and an Article III court where you're a generalist?
The similarities are the advocacy. I mean, you see attorneys who are there representing their clients, their different positions. The oral argument is the same. Absent a jury, the trials are the same. So procedurally, process-wise, very similar. The differences are, I think, that bankruptcy has the luxury of being, you referenced being a generalist on the district court, bankruptcy has the luxury of being confined to one practice area. And it really is a luxury. The entire code is contained in that book. You can look up any statute that has to do with bankruptcy right there. You get people who are very expert and knowledgeable about what they do because it's all they do, and they do it all the time. You get an extremely collegial bench because bankruptcy practitioners know that they're going to see each other next week or next year. They're going to see each other in a case in New York, and then they're going to see each other in a case in California. And if they don't treat each other with respect, and they don't treat the judges with respect, it'll come back to haunt them.
Well, is it the same in district court with, say, AUSAs and defense counsel?
It's much more similar, yes. The criminal bar, AUSAs and defense counsel, also seem to be much more respectful of each other, much more collegial. The civil bar is scattered all over the country, and quite frequently they may see each other on a case once ever in their careers. And I've been kind of surprised at the extent to which that can lend itself to sort of childish bickering and, filing motions just to be the last person who filed the motion, and not in all cases, of course, and not all lawyers, but I've seen a lot of that. I've also seen that bankruptcy is eminently practical. Not everybody has a lot of money. In fact, most people don't. If they did, they wouldn't be in bankruptcy court, whether it's a business case or a consumer case. And so they're not really anxious to throw a lot of money at a problem if there's a more practical way to solve it. In civil litigation, it sometimes seems as if the practicalities and the workout strategies, if you will, to use bankruptcy terminology, tend to get lost in the weeds because they've got enough money to file another brief and file another motion and make another argument and come to court for another thing. So that's been a big difference to me.
Well, let's see, you've been on the bench now about 18 months.
Yeah.
Have you pulled a bankruptcy appeal yet?
I have not.
Really?
I have not had a single solitary bankruptcy appeal. And I've been disappointed, actually. It's the one thing I still have a little bit of a recollection about. And I haven't had one. And I've been wondering why that is. Is no one in my district appealing anything?
Well,
or have I just not gotten them? I don't know.
maybe your bankruptcy judges are getting it right.
I hope so. Considering my colleagues, I bet that's exactly what's happening.
You came into the district court bench very well prepared for criminal matters because you were defense counsel as well as being an AUSA before you were in private practice. What is it like now returning to criminal law after having been away for so many years?
This is going to sound a little bit odd, but there were many things that I saw in bankruptcy that reminded me a lot of what I saw when I was a criminal practitioner.
How so?
In the sense that bankruptcy, particularly consumer bankruptcy, which we did a lot of in the Eastern District of Wisconsin, bankruptcy finds people at crisis points in their lives. The worst things have happened to them, things that they didn't expect or anticipate. Their lives are in disarray. They're worried about losing their families, their homes, their jobs. Criminal law is a lot like that. You see people who have made mistakes, some deliberate, some less deliberate. They never thought they'd end up where they are. They are miserable about ending up where they are. And so there was almost a sense in which coming back to criminal, I remembered a lot of it, which shocked me. A lot of it's changed, but a lot of it hasn't. But it is still seeing every day people who are in crisis, people whose lives have taken directions that they never wanted them to take or anticipated that they would take, and trying to figure out now how to make the best of what is already a bad situation. So that transition and coming back to that actually has been a little bit easier than transitioning to the general civil practice.
Let me ask you this. Maybe this is not a fair question exactly, but compare your days sitting on the bench in bankruptcy court and in district court. Which is more interesting or stimulating or boring for that matter? Or are they all the same? Is judging the same no matter where you are?
To be honest, I don't think I've ever had a boring day on the bench on either court. And in both courts, there have been days where things happen that never in a million years would you have predicted would happen. I had a debtor in a bankruptcy case once tell me that she loved me, which I never would have predicted would actually happen while I was sitting on the bench. On the district court bench, I have had a gentleman whose parole supervised release I revoked, who then serenaded me with a Christmas carol that he had modified somewhat based on things that he didn't think were that good about it. And he sang 7 verses of Silver Bells, his version. So, in that respect, both of them, I don't think that I've had many boring days on either court, which is a blessing. I mean, who could say that about their jobs? I will say when I'm on the bench in district court, you never have, it seems to me, you never have a 15-minute hearing. In bankruptcy court, frequently, particularly Chapter 13 motion day, I could have 30 hearings in a day, 35 hearings in a day. In district court, that rarely happens. In district court, it seems like everything needs briefing, pretty heavy-duty briefing, and everything takes a significant amount of time. And one of the things I'm trying to adjust to is, in bankruptcy court, I felt like I could carve out enough time during the week to get the written and research work done that I wanted to do. I find that a little bit harder in district court because I'm sitting out there for longer periods of time. Even for motion calls, I'm sitting out there for longer periods.
Do you have a soft chair on the bench?
I have a soft and ergonomic chair on the bench, I do. I have been tempted to take a snack out there with me, but I've decided that I can't quite go there just yet. But when you've been there for 3 hours, you start to lose your attention span if you get hungry. So I've been thinking about putting some M&Ms underneath there.
That's a good idea. Tell people it's a medication.
Right. I'm sorry. I have to take my pills and then have 3 green M&Ms.
Yeah, that's right. Well, Judge Pepper, let me tell you this. I love the Seventh Circuit. It's my favorite circuit. The bankruptcy law that comes out of there is wonderful because they still have a sense of equity on the Seventh Circuit. And of course, I love Judge Posner's decisions.
And Judge Easterbrook?
Well, Judge Easterbrook has written fewer bankruptcy decisions in the last few years than he used to.
Right.
Judge Posner seems to be taking most of them, but I hope sometime very soon they move you to the Seventh Circuit so that Judge Posner doesn't have to write all the bankruptcy opinions.
Well, I don't know that that's going to happen very soon, but I will tell you that the Seventh Circuit has a tradition of inviting district court judges to sit by designation with the circuit, partly to help with their caseload, but more actually just, I think, to give a district court judge an idea of what it looks like from the appellate side. So last week I got to sit twice with the Seventh Circuit.
Well, I hope you get a bankruptcy appeal on the circuit if you don't get one in the district.
Thank you.
Well, Judge Pepper, thank you very much for joining us today. Be well, and I look forward to seeing you on the circuit, I hope, soon.
Thank you, Bill. I appreciate it.